Good morning. This is your Kelso Report for Monday, March 26th, and I'm your host, Clark Kelso. Well, today we're going to begin with my forecast of what I think the Supreme Court is going to do with the Affordable Care Act. Big arguments this week. I'm going to make a prediction. Then we'll turn to the cases involving search and seizure, arbitration, probate law, and criminal sentencing. Let's begin with a Kelso pick. The big news this week is, of course, that 6 hours of argument have been scheduled by the court to consider various issues involving the Affordable Care Act. On Monday, the court will hear 90 minutes of argument on the applicability of the Anti-Injunction Act. Tuesday has 2 hours for the minimum coverage provision, that's the individual mandate. Wednesday morning has another 90 minutes for severability, and they close Wednesday afternoon examining issues involving Medicaid. I'm not going to predict how the court will rule on all of these issues, but I do want to give my best guess about the individual mandate requirement. I believe it's most likely the court will strike down the individual mandate. Not because the mandate somehow violates the Commerce Clause, but most likely because the mandate cannot draw support from the Commerce Clause. That is, it is entirely outside the purview of the Commerce Clause. And there's no other provision in the Constitution which would authorize such a mandate. The Commerce Clause under this analysis is relevant when Congress is regulating commerce or regulating a market. And if the court were to decide that the mandate constitutes a form of market regulation, then I think it would easily uphold the mandate under the court's current Commerce Clause doctrine, which gives Congress quite a bit of power. But I think Justice Kennedy, who's probably the key swing vote in the case, is likely to decide that the mandate does not itself regulate the market. Instead, the mandate requires someone who is not currently participating in a market to enter that market without their consent. And in so doing, the mandate goes beyond the power granted Congress by the Commerce Clause. Mandating participation in a market is not the same thing as regulating a market of voluntary participants. Now, proponents of the mandate have asserted that essentially everyone is necessarily a participant in the healthcare market just by virtue of being alive and becoming sick and dying. But that argument proves, I think, way too much, which is why I think Justice Kennedy will reject it. If being alive is enough to trigger Congress's Commerce Clause powers, then the Commerce Clause really has become the equivalent of the general police power, which has previously been properly understood as part of state sovereignty and not part of the enumerated federal powers. The Founding Fathers would, I think, be rather shocked to learn that the Commerce Clause actually conferred broad police powers on Congress. And I think the Supreme Court will strike down the individual mandate in order to preserve the limits on Congress's power. We'll only have a couple of months to wait to see what the Supreme Court does. Let's turn now to our cases. First, search and seizure case from the Ninth Circuit. In United States v. Wynn, the defendant was convicted of 1 count of obstruction of justice for failing to disclose the full extent of his knowledge regarding the mailing of a letter that could reasonably have been believed to constitute an attempt at voter intimidation. The letter had been secured by state law enforcement officials pursuant to a warrant authorized by a state magistrate. Subsequently, state officials decided not to prosecute the defendant under state election laws. Nevertheless, the Ninth Circuit held that the contents of the letter and the circumstances of its distribution were sufficient to allow the magistrate to conclude that there was a fair probability that the mailing constituted a violation of California Election Code Section 18540. In particular, the letter targeted immigrant voters with threats that their personal information would be provided to anti-immigration groups if they exercised their right to vote. And it was mailed by a campaign with a vested interest in inducing these voters not to vote in the upcoming election. These facts created a fair probability that the distribution of the letter constituted an act of voter intimidation under California law, and that provided a sufficient basis for issuance of the warrant. Next, we turn to a technical arbitration decision. California Court of Appeal in Thomas versus Westlake. An investor's successor in interest tried to avoid arbitration by arguing that only one of the defendants was a signatory to the arbitration clause and that there was therefore a risk of inconsistent judgment. But unfortunately for the plaintiff's own complaint alleged that all co-defendants were acting as agents for each other, and the lead defendant had signed the arbitration agreement. Applying basic principles of agency, the 4th District held that a non-signatory to an arbitration clause nevertheless has authority to invoke the clause as part of his agency powers. The plaintiff argued that these basic principles of agency applied only to benefit the plaintiff in his effort to hold all defendants accountable for their wrongdoing. Well, needless to say, the court rejected the idea that the law of agency is a plaintiff-only law. Agency law is equally available to defendants, and in the circumstances of this case, that supported a holding, making the entire dispute subject to arbitration. Next, we have a case involving a probate law question. In Donkin versus Donkin, the 2nd District had to decide whether to apply retroactively the repeal of a safe harbor involving no contest clauses that was in the probate code. Certain beneficiaries of a family trust wanted to challenge some provisions in the trust, but wanted to avoid the negative consequences of a no contest clause. Pursuant to a safe harbor that had been placed into the probate code and that existed when they filed their action, the beneficiaries sought a determination under Section 21.320 to determine if their challenge would trigger the no contest clause. The legislature had added this interesting provision that lets you come in to have a contest about whether you trigger the no contest clause. Well, subsequent to their filing, the legislature wisely repealed Section 21.320. The trial court in this case, though, applied the pre-repeal law and held that the challenges would not constitute contests under the Act, although the court did not conduct a full hearing on the merits. The 2nd District held that the Superior Court was correct to apply the pre-repeal law because all parties had relied upon Section 21.320. But the appellate court reversed because it found at least one of the provisions was a contest as a matter of law, because the challenge would upset the distributive scheme of the trust. As to the other challenges, the court remanded to the Superior Court to conduct a full hearing on the merits. And we close with a criminal sentencing case in People versus Maharaj. A jury convicted the defendant of multiple counts of lewd and lascivious conduct involving the same victim, a young girl under the age of 14. In count 1, defendant was convicted of forcible, lewd, and lascivious acts on a child under the age of 14. Then in counts 2, 3, and 4, defendant was convicted of aggravated sexual assault on the same child. The conduct in count 1 occurred on a separate occasion from the conduct in counts 2, 3, and 4. On all 4 of the counts, the court imposed consecutive sentences. The defendant complained that subdivision C of section 667.6 of the Penal Code, as previously interpreted by the 3rd District in People versus Goodliff, made the consecutive sentences unlawful because the conduct occurred on separate occasions. Goodliff did indeed involve conduct that occurred on separate occasions, and in the circumstances of that case, they held the consecutive sentences were unlawful. But that case also involved non-forcible sex crimes that were not covered by subdivision E of section 667.6, which expressly authorizes consecutive sentences for such crimes, whether or not they took place on the same occasion. In other words, Goodliff was distinguishable since subdivision E's express authorization trumped subdivision C as interpreted in Goodliff. Bottom line, the defendant's consecutive sentences were affirmed. And that's it for today's Kelso Report. Have a great day in the law.